Right, good morning and welcome to the District of Columbia Court of Appeals. I'm joined this morning by Senior Judge Eric Washington and Associate Judge Roy McLeese, and I'm Chief Judge Blackburn Rigsby. We have two cases set for argument this morning. Our first matter is LUKMAN AHMED versus BBC or British Broadcasting Company. Counsel, are you ready to proceed?
May it please the court. I am Deanna Maria Lewis on behalf of the appellant LUKMAN AHMED, and I respectfully request to reserve 3 minutes for rebuttal time. The amended decision by DC Superior Court Judge Yvonne Williams, which granted the appellee, BBC, the defendant, its motion for summary judgment and motion for reconsideration, which ultimately dismissed the appellant's claims in its entirety as seen in Appendix 142, should be reversed and the case remanded for trial for 3 reasons. 1, the appellant established a prima facie elements of race and national origin discrimination, as well as retaliation pursuant to the DC Human Rights Act. 2,
Counsel, can you walk us through the prima facie elements for the discrimination claim? Because while a couple of those elements may have been met, I'm concerned about the fourth element. So if you could just walk us through why you think he's sufficiently made out the prima facie claim.
Yes, Your Honor. As we iterated in our brief, and to respond to your question, Chief Judge Blackburn Rigsby, we believe that there is no dispute that Mr. Ahmed is a member of a protected class. We also believe that there is no dispute that he was subjected to an adverse action when he was terminated.
And protected class, you mean
He's
race and national
race
origin?
and national origin as a Black African Sudanese person. We also believe that he was subjected to an adverse action when he was terminated. Additionally, I imagine the questions about causation and the proximity.
Mhm.
We believe that there is causation and proximity as well. And we established that because over time, there is evidence in the record that once his predecessor and former coworker, a white female, no longer served on that same desk as he did, there was indication that he made multiple and repeated requests for assistance.
Now, when you say over time,
Yes.
doesn't that negate the proximity argument? Because we have cases that show that the proximity is, 2 weeks proximity is too much in some of our case law. And here you're talking about his requests for additional staffing over a 12-year period.
Yes, sir.
How does that meet the proximity?
Yes, Your Honor. We believe that based on the time frame, in terms of when he was complaining and when he went on vacation for that 2-month time period, when he went to Sudan, as he had been doing for the last 12 or so years prior to his termination, it was in this time frame, prior to this time frame actually, that he had been, those time periods of complaints, if you will, had been increasing. And as it relates to the time that he actually went on the vacation, when he came back, he continued to express concern about the fact that there was no additional resources for him. There were staffing concerns.
Right, because I think the idea is, the question, one way of looking at the question is if he has been continuously complaining at kind of the same rate in the same way for 12 years, and then at some point he's terminated. And the issue, this is focusing, I guess, on retaliation in particular. It just seems unclear why you would connect the termination to the complaints, because that had been going on for 12 years without termination, and then all of a sudden there's termination without any obvious connection between something that had been going on for 12 years and a termination that happens. So what's the how do you respond to that way of looking at the concern?
Yes, Your Honor, we can understand why that seems to be a concern for the panel. Here, we think that it's because there was an increase closer in time to his termination of complaints. We believe that he did establish that in his deposition, which a transcript is cited to in not only our brief, but also as an exhibit of the joint appendix. And so as it relates to the timeframe issue,
Can you, I mean, can you be specific about what exactly the deposition testimony was that supported the idea that there had been kind of low-level complaints, then they obviously apparently were not enough to trigger retaliatory termination, but then there was kind of a significant alteration right before termination? What concretely, exactly what did he say in the deposition that supports an idea that there was an increase?
So, Your Honor, and thank you for that question, Judge McLeese. In the deposition, and I'm paraphrasing because I don't have the specific citation right offhand to the answer to that question, he indicated that he had in multiple times indicated to his assignment desk his supervisor directly, who was based in London, that he was understaffed, that he needed help, that he was the individual out of all the other desks, the Persian desk. He was a member of the Persian desk, the Russian desk, and the English desk. He, as a person for the sole person and sole Black Sudanese person manning the Arabic desk, he had more work than anyone else. And this was, in terms of temporal proximity, this was related to the time frame where he had no other staff members present to assist with this need. And so in comparison to the other desks that existed, there were desks where we've cited to, some of the desks had 30 staff members.
Ms. Lewis, but we're talking about, I thought the question had to do with the issue of whether this is a pattern of antagonism, first opportunity, and you're claiming that at least that somehow there's evidence in the record that while he complained at certain level for years, that right before he was terminated, there's evidence in the record that those complaints that he lodged were increasing, that they were significant, such that it would cause them to wait to retaliate at that point as opposed to earlier when he had raised the exact same concerns. Not an easy thing to show. But will you be able to show us? Do you believe there is record evidence to support that claim, or is your claim things just got worse, so therefore he must have complained more, and therefore they must have taken this action against him?
Well, thank you for that question, Judge Washington. So I have found the citation in our briefing, and if you look to Joint Appendix 887 through 889, we believe that does reflect from Mr. Ahmed's deposition his discussion concerning the various complaints that he was making as it relates to the need for additional porters at the Arabic language desk to alleviate what he perceived to be an unfair workload and excessive deployments. And so to your question, Judge Washington, I think part of our argument is the latter portion of what you cited, that closer in time to when he was leaving, closer in time to when he asked for time off, when it was approved by that phone call from his supervisor, and that he consistently discussed with Mr. Sam Farah, as well as Bassam Adari. And you can see those references at Joint Appendix 930 and 931, as well as Joint Appendix 935, that closer in time, over time, because the staffing.
Closer in time, though. Overtime is the entire time he's been there after he lost, and probably even, there's no evidence that he wasn't complaining before he lost his one other desk mate on the Africa desk, right? So overtime doesn't answer the question that Judge McLeese was posing to you, and doesn't provide us sort of with a basis for concluding that this was the cause of his termination. So if you keep using the word continuous, you're losing me.
Right.
I need increase.
And that sort of goes to my initial question of, doesn't overtime over the course of 12 years negate the causal connection? But I also am questioning how his complaints never mentioned discrimination over time. The complaints talked about staffing, general staffing issues, nothing to signal to the employer that this was a racial discrimination claim or a national origin discrimination claim until he files his claim and claims discrimination. And you cite in your briefing to a case, Jones versus United Health, from the Maryland, it looks like Maryland Intermediate Appellate Court. I think. I guess where's the how do we tie the discrimination that you're claiming occurred as we get closer in time to the termination to him being in a protected class when he never really mentions racial discrimination or national origin discrimination?
Yes, understood, Your Honor, and thank you for that question. In this case, and yes, as we cited in our brief to Jones, and that's 2019 Westlaw 1903668 at 13 and specifically, in that case, essentially the court, the U.S. District Court of Maryland, indicated essentially that racial dynamics were implicit in the circumstances. In that particular case, it was about a Black employee who complained that she and another Black employee were treated unfairly, while another quote unquote type of person, their white colleague, benefited. Here, Chief Judge Blackburn-Wixby, to answer your specific question, Mr. Ahmed also complained about what he understood to be unfair distribution of work. He was the only and sole Black Sudanese African correspondent at this desk, and also the only one based in the Washington, D.C. office. And so as a result of that, as a result of him comparing himself implicitly to the other racial dynamics of the other.
Implicitly. And so you're saying that this Jones case allows for an inference. I mean, here it's a little interesting because the BBC is an international organization with reporters, journalists covering different parts of the world and different languages. And he does say that his Arabic assignment for covering Sudan wasn't staffed the same, and that his deployments were more frequent, but then he doesn't tell us anything about why he believes they were more frequent. He doesn't remember, or says he doesn't remember how frequently he deployed, and that he doesn't know how frequently anyone else deployed. So how is that a sufficient basis, I guess, to get over the prima facie hurdle?
Understood, Your Honor. Thank you for that question. Here, similar to the Jones case, the court in that case indicated that the context clearly conveys racial impetus. In other words, a reasonable employer should have understood that the nature of the complaint was that of discrimination. And so being that in terms of the optics of the assignment desk, he was the only Black African Sudanese member. So race and national origin from all the other, and yes, Your Honor, you're absolutely correct, that this is a diverse organization. But in terms of him being the only Black, he was representing as the only Black, non-white or non-white adjacent, if you will, individual from a very specific and clearly different protected class. And so to your question, it is our position that based on those circumstances, based on the fact that he was expressing to his supervisors that he had an inequitable distribution of work, that he did not have proper staffing, that when you look at everyone else and all their other assignments desks, being that he was the only individual in the Washington, D.C. office, one thing looked very different from the other. Visually, Mr. Ahmed is a very dark African-looking man.
But how do we know on this record that his workload was so significantly different from anybody else's? Just because there's more people on a desk covering more cases, is there some place where that is actual evidence in the record that they were working 4-hour days and getting paid the same amount as he was working 20-hour days?
Well, Your Honor, thank you for that question. And so part of the deposition transcript, Mr. Ahmed did testify that he felt like he was working 24/7.
No, not felt. Is there evidence that in fact he was being asked to do more clearly than anybody else in the working for the BBC, such that he could compare himself, other than I'm working at a desk alone and they're working at a desk with 10 people, since we have no evidence in the record as to what that work entailed versus what his work entailed?
Thank you for that clarification, Your Honor. And so in terms of the evidence, part of our issue in this case is the fact that we did request information in discovery pursuant to a motion to compel to receive information regarding desk assignments, which Judge Yvonne Washington denied. And so in terms of the circumstantial argument from the direct evidentiary standpoint that you're asking about, we don't have some of that specific information because we did request it. However, we were not able to make that a part of our case in chief. And so
Well, there
we
were
do-
some surrounding circumstances with respect to the motion to compel, because Mr. Ahmed did not comply with numerous orders from the court for discovery in a timely manner, and was not really available. He was out of the country and not participating in the lawsuit that he brought. And so I gleaned from the transcript some frustration on the part of the trial judge that he was not making himself available to comply with reasonable discovery requests that were being made of him as well. So I'm not sure see, or I'm open to hearing how she abused her discretion by denying his discovery request.
Well, Your Honor, thank you for that question. Yeah, it absolutely was frustrating. I think probably for everyone who was a party in this matter, as well as for Mr. Ahmed himself. And part of that is because at the time he was abroad, like counsel had cited to in their reply brief, he was abroad. I mean, he was in a war-torn country. In fact, Sudan right now is considered one of the most egregious humanitarian crises that is occurring in present day. And so because he was there, there were many, many instances which my co-counsel did communicate to BBC's counsel that he was not in a position to access internet. There's a significant time difference. And a lot of times he was concerned for safety reasons because of the circumstances in which he was living at that time and is currently still living, actually. And so we certainly do understand the frustration. And obviously, there's some cultural differences in terms of the understanding of kind of the American justice system and how, you know, things may be done in a different foreign land. But when he was able to communicate, and as his lawyers, we took great efforts to contact him, to get in touch with him using different means of technology to do so. And there were times when we had to have calls at odd hours of the night just to actually get in touch with him. But he has remained steadfast despite the delays, despite the instances where he was not readily available, even to his lawyers to respond. And so, yes, Your Honor, it absolutely was a very frustrating experience for everyone. But we do believe that since we are here today, it is at least apparent that he does have continued and has maintained continued interest in prosecuting his case. And I do see
Did
that
you-
my time has expired. Would you like for me to continue?
Did you want to very briefly address the wage claim?
Your Honor, we will stand on our brief as it relates to the wage claim.
Okay. We'll reserve a couple minutes for rebuttal and hear from appellee now. Thank you.
Thank you for your time.
May it please the court, Your Honor. My name is John McDonald, from the law firm of Reed Smith, representing happily the BBC Corporation. I think the panel has already seized upon some of the key issues that we address in our briefing, the absence of any prima facie case here, because there's just an absence of any tying of the appellant's race or national origin to any of the things, the workplace issues of which he claims he complained over a period of 12 years. You know, just the mere fact that he happens to be Sudanese and he happens to be Black is not in and of itself evidence that those inherent characteristics of the individual were the driving
Let
force
me ask you,
behind.
counsel, if we were to conclude that he had in fact made out a prima facie case for the discrimination claim and the retaliation claim, can you just summarize again the reasons that are non-pretextual that would be a part of the BBC's response?
Thank you, Your Honor. Yes, as we put in our brief, even if he had established a prima facie case, there is no evidence of pretext in this case. And obviously, once a prima facie case would be established, the BBC's burden of production is to provide a legitimate, non-discriminatory, and in this case, non-retaliatory basis for its decision, which it did quite in detail. The plaintiff, appellant was on vacation.
He said he was given, I guess I know I asked you to explain, but now I'm gonna pinpoint.
Fine, Your
He
Honor.
said he was given verbal permission to interview or talk to the president of the Sudan. And I know that there's a there appears to be a factual dispute about that. With BBC saying he wasn't given any verbal permission to do so and him saying that he was. Isn't that a sufficient basis for this to go forward past summary judgment, since that seems to be the key reason for his termination, if I understand correctly?
It is not, Your Honor, because it does not create a material issue of disputed fact, and I'm happy to explain why, and it's for two main reasons. The first is that even if he had received verbal permission from his supervisor, which of course his supervisor denies, and it's unclear from plaintiff's own testimony what permission he received, what he received permission to do. He indicated he was going to do an interview for his charity, and of course, as shown in the record, the interview had nothing to do with his charity. But more importantly than that is the fact that the BBC did a full investigation when it learned of this issue, that multiple different decision makers were involved in that situation and in making that decision, that the appellant himself was given an opportunity to explain what happened. And even if he got verbal, this is the most important thing, even if he got verbal permission from his boss in London, what was required to do that kind of interview was written permission from the DC Bureau Chief, Paul Danaher.
When you say required, based on the written policies of BBC, which there was evidence that he was aware of?
That is exactly correct, Your Honor. I will state that the appellant in this case testified with great candor during his deposition that he was aware of all of the policies, the non-discrimination policies, the conflict of interest policies that Your Honor just referenced. And he was fully aware of what he needed to do. In fact, there's evidence in the record that in 2015, the appellant or plaintiff went to Paul Danaher, the DC Bureau Chief, and let him know that he was working for a charity. So he knew how to do this. He knew how to get permission, and he knew from whom he needed to get permission, as he demonstrated in 2015.
Counsel, is there evidence in the record that would support a conclusion that, or dictate a conclusion, maybe even, that your client would have terminated Mr. Ahmed, even if it were true that he'd gotten verbal permission to conduct an interview, and that the problems instead were more limited and had to do with editorial guidelines and the like? Is that something that there was evidence kind of about which of the various components of the BBC's view of what all was done wrong were load bearing and which might not have been?
There absolutely is evidence of that, Your Honor. The Human Resources Department that conducted the investigation issued a report in which they found multiple violations as a result of that interview with a state, president of a state that, of course, the BBC would be very interested in having on their own channel, and was instead on a competitor's channel. Things like violating the conflict of interest policy, he didn't vet the interview beforehand. It didn't follow BBC guidelines. For example, did not contain what the BBC called a challenging question, that it was kind of it was kind of a puff piece. It was very favorable to the Sudanese president, which is also against BBC guidelines. And this is all laid out quite clearly in the record in the HR's report, which was then conveyed to not only appellant's supervisor's supervisor, but also that person's supervisor and legal. And there was a committee that made the decision to terminate.
I understand all of that, but my exact question, and maybe you're implying something about it, was there evidence that if you subtracted the lack of permission, if you'd said, okay, even if it were true, that Mr. Ahmed's version of the conversation with his supervisor was accurate, the other respects in which what Mr. Ahmed did was inconsistent with our policies are so grave that we would have discharged him for those alone? That was my question.
And yes, Your Honor, apologies if I didn't articulate myself clearly. There is evidence in the record that he would have been terminated regardless of whether he had verbal permission from the incorrect person from whom he needed written permission, and all those
And is
things I
that,
mentioned.
I mean, when you were first taking a cut at answering that question, you kind of listed, well, there's a report that's listed all the infractions, which you could say is some evidence that that those other infractions were material to the decision. But was there something more where they, as somebody said explicitly, this is really grave about the, the lack of a challenge question or the lack of, the competitive component of it, or anything that is more than simply that it was listed as part of what seemed to be germane to the people making the report, and then maybe inferentially to decision makers who are acting upon the report?
I think the most clear is the fact that it was found by the HR department that the way he conducted the interview was a gross violation of the conflict of interest policy, but I do not recall there
So they
being.
use the word gross.
Yes. I do not recall there being evidence in the record, for example, that anyone was asked, the direct question, had this been true and these other things not been true, would he still be fired?
Mr. McDonald, can I just going back to the prima facie case? Ms. Lewis and the appellant here rely on Jones. Why isn't Jones, in your opinion, a case that provides support for their claim that they survive, at least on they met their burden of showing prima facie discrimination?
Thank you, Your Honor. Yeah, like the trial court found with regard to Jones, it's quite distinguishable from this situation because the plaintiff in Jones presented evidence that the plaintiff likened and compared herself to her coworkers who were of different race and different protected characteristics, and claimed about the unfairness directly. This person's being treated is better than me. This person is being treated better than me, and it's unfair. And use those kind of words as opposed to this case.
In Jones, was there evidence or just claims? Evidence of specific examples of unfair treatment for her comparator evidence in Jones?
There was, Your Honor. There was just more specific evidence comparing someone outside the protected class with someone inside the protected class, such that the court in that case held that the employer should have known that these comparisons by the plaintiff to her coworkers who are outside the protected class in these unfair specific situations, as opposed to this case like the trial court held, where most of his complaints could really be described as general workplace complaints. I'm overworked. Everyone thinks they're overworked. I'm deployed too much, but as Your Honor's pointed out during your questioning, there's no evidence.
It's a little hard to hear you, counsel. I
Sorry,
apologize.
Your Honor.
Thank you.
There's no evidence in the record how many times he was deployed versus any single comparator outside any of the protected classes, which is obviously a big issue in this case because there's no tying his deployments, if we knew how often they were, to his race or his national origin, or a difference between someone outside those protected classes. In fact, he had a producer who went on all of his deployments with him who was outside both of his protected classes. So she was treated exactly the same as the appellant and yet was not Sudanese and was not Black.
At least for a portion of the time period at issue. I forget exactly. Do you know off the top of your head when the producer came on scene and then started accompanying him on all his?
I don't remember the exact date. I believe it was roughly 2009, 2010. So it would have been for about 9 years that they were being treated the same, roughly.
What about, and I guess this could go to, I don't know, prima facie case or to BBC's non-pretextual explanation. What about Mr. Ahmed's claim that it was not an interview with the president of Sudan? It was just a conversation. It's his countrymen. It wasn't a formal interview that he needed the kind of permission that's set forth in the conflict of interest policy.
I think that description, while novel and interesting, is not material to the discussion because the employer is allowed to make its own determination as to whether it believed it was an interview and whether they call it a garden talk, as in their most recent briefing, or some type of discussion or casual talk. As plaintiff said at the trial court level, there were questions.
But isn't
and then
that
there were
though
answers.
a future, a disputed fact?
I don't believe.
Whether it was an interview or a conversation, BBC says it was an interview. Mr. Ahmed says it wasn't, it wasn't that formal, didn't meet any of those guidelines. Isn't that a factual dispute?
I do not believe is a material factual dispute, Your Honor. I think a few things I'd like to point out at that. One is, if it wasn't an interview, then what kind of permission did he actually get when he described himself? And if the BBC is not allowed as the employer to look at the facts, including his own social media postings at the time, which described it as an interview, which is in the record, and was part of the reason that the company made the determination that it did, that it was in the company's mind and in their determination, which they're allowed to do, it was an interview that violated their policies and procedures. What the appellant has to show in that situation to create a material issue of fact would be that the BBC didn't believe that when they said it, and it was a pretextual reason, a false reason from which a jury might be able to determine that some other nefarious motive must have been behind it. No such evidence exists in the record.
Or they could have, if he had produced evidence that other correspondents at the BBC had conducted similar interviews and not been disciplined, or the BBC or similar conversations and had not sought permission and not been disciplined.
Correct, Your Honor. Had he brought forth any evidence of a single comparator who had had a garden discussion, a casual discussion that was brought to the BBC's attention as being potentially an interview that violates its policies, and they had not investigated it or not issued the same discipline, and that person was outside either of the protected classes, that would be evidence that could go to a jury, that could send this case to a jury. But there is no such evidence of any comparator that was treated differently on any scope or scale of the type that are being presented by appellant in their briefing.
Can I ask you briefly to address the wage claim that Mr. Ahmed raises, and I guess focusing on the denial of his motion to compel, I guess?
I can address both issues. So quickly, the wage claim issue, there's no evidence that there was any late payment of any, no admissible evidence that there's any late payment of any wages. There was a direct deposit record that was attached to plaintiff's counsel's declaration during the motion to compel proceedings, which was then referenced during the trial court summary judgment briefing as somehow being evidence that it was wages. But my opponent's, first of all, has no personal knowledge. A lawyer, it's just argument of counsel. A lawyer has no personal knowledge of what that bank record was. There was no even discussion in any of the briefing of what they could do to cure that aspect of it had the case gone to trial. There was just no admissible evidence that he was paid late. And his own testimony was, I don't have a wage claim. I received all my wages. So there's just no evidence for the wage claim. And to turn to the motion to compel issue, Your Honor, if I could, in these 47 seconds, describe it as quickly as I can. They wanted a record that didn't exist. They wanted a centralized database that they could push print. I was told that many times. We could just push print and print out everyone's deployment records. And there's just no such database, as we put in our briefing and as we explained during the motion to compel, and as the judge asked herself of my opponent during oral argument on the motion to compel. We did produce a lot of records involving deployments, 3,000 such pages, when we were able to find that word in various emails and things. But again, you can't really tie them to this person had this many and that person had that many, because if person A didn't email about it or person B's supervisor didn't create a record, we couldn't really compare. It would be apples and oranges forever into infinity.
The trial court's ruling, written ruling at least, on partially granting and partially denying the motion to compel didn't really explicitly rely on the point you were most just now kind of leading with, which is there was a request for the information in a form that we didn't have it. So we really couldn't, we had no way of responding other than to say that we don't have the thing you're looking for in the form you're asking for it. The trial court's points were two different one very different one, and one that, is at least not explicitly that. The first was, can't really tell what they're asking for because they don't quote the exact interrogatories and the like, which seems like a debatable line of thinking. if, as I believe to be the case, the interrogatories were attached to the motion instead of quoted in the motion. So that's number one. Do you defend that as like an independent, adequate basis for denying the motion?
I think it was a basis for the judge's decision. I think it is an appropriate basis for the judge's decision. I think abuse of discretion is the standard, but I do agree that the interrogatories were attached as an exhibit, and from one could clearly see what was asked for and what the response was.
So the second was really to refer to the hearing and say, it appeared, this is paraphrasing now, but this is how I understand what the trial court's getting at. There was a motion to compel to get a lot of things. At the hearing, it was made clear that many of those things had been provided. It's not so clear to me what the remaining disputes are. There's one thing that I can tell hasn't been provided that I think should be provided, so I'm going to require that that be provided. But otherwise, I can't really tell what else is going on, so I'm not going to grant the motion to compel beyond the one thing that I can tell. It hasn't been provided and they're entitled to be provided. That isn't really so much. I mean, that may or may not be a good reason for denying or partially denying the motion to compel, but it wasn't really I know what's being requested here. What is being requested is a printable version of a database that will allow, assessment of exactly who traveled where when. And that doesn't exist. So I'm denying the motion to compel because I can't compel people to give things that don't exist. It wasn't really that line of thinking. So
Well,
it's a little hard for us to affirm on that line of thinking if that wasn't the trial court's.
I think there was during the exchange in the oral argument on that motion, there was an exchange that did go through that where the judge did ask, as you just pointed out, for a more specific articulation of what was asked for and missing. And the answer was, well, they just produced a bunch of stuff, and I'm not really sure. And maybe it's been taken care of, and maybe this is no longer an issue, and couldn't really articulate what was being sought. But the judge also did mention that people had represented, myself included, as well as one of the witnesses, that it didn't exist in the format that they were seeking. My time has been up for a bit, so thank you.
All right, thank you. Ms. Lewis, you have 2 minutes for rebuttal.
Thank you, Your Honors. So there are a couple of things that we do think are important to mention, particularly as it relates to this investigation. So first and foremost, Farah and Andari were the antagonists in Mr. Ahmed's complaints, particularly in the complaint that he filed at the DC Superior Court level. And the other reality is, based on the false assertion specifically, Mr. Andari indicated to BBC that Mr. Ahmed's assertion that he had received permission for the interview was false, which is not true. It was not false. He called and specifically requested to do this, well, what obviously is a disputed fact, whether or not it's an interview or not, but to have this communication. It was also asserted that Mr. Ahmed never mentioned to Mr. Andari the Prime Minister or an interview of him of any kind, and that Mr. Andari would have never granted permission for such an interview. And if Mr. Andari had known that Mr. Ahmed had access to the Prime Minister of Sudan, he would have had Mr. Ahmed obtain an interview on behalf of BBC. The reality is this was not the first interview that Mr. Ahmed completed with the Prime Minister of Sudan. And while there is a kind of seemingly misunderstanding on Mr. Andari's part about whether or not the Prime Minister of Sudan was in fact the Prime Minister of Sudan at the time that he was the Prime Minister of Sudan, that is not a dispositive issue. That is in fact more argument as to why this is a pretextual argument. The reality is Mr. Andari omitted this prior permission as a part of this report that Mr. Fair relied on.
If we credit Mr. Ahmed's belief that he received verbal permission to do this interview, where does that leave us when you have the written policies of BBC about conflict of interest regarding these types of high-level interviews, where the policies say that written permission from the head of, I think it's the head of BBC, not just your immediate supervisor, is required. And there's no dispute that he didn't have that.
That's correct, Your Honor. He did not have the written permission. And part of the reason for that is because it was not considered an interview from Mr. Ahmed's perspective. And so also, as the record demonstrates, this policy that's being referenced was implemented in 2019. Mr. Ahmed gave notice to the director that you just mentioned back in 2015 that he was volunteering for this particular organization. And while back in 2015, this wasn't necessarily a communication about whether or not he could have a sit down in some sort of fireside chat, if you will, with the Prime Minister of Sudan. The reality is they were aware that he was involved in this organization. Part of BBC's argument is that, during this conversation, if you will, with the Prime Minister of Sudan, his nonprofit was never mentioned. That's not dispositive of the issue here. And Your Honor, I think it's absolutely right when the panel asks, well, isn't this a genuine issue of material fact and dispute as to what, in fact, a trier of fact would characterize this conversation as? We absolutely do believe that is a material issue of genuine fact in dispute, because it should be a trier of fact that makes that determination. The fact that Mr. Ahmed on his Facebook social media page characterize it as an interview does not mean anything in relation to what the intent behind it was. When you're posting something on social media, you may not say, oh, I'm going to post this fireside chat. I mean, it's a social media post. It's not like he's providing some academic reference to it. As it relates to the intent behind it, it was a recorded conversation, a visually recorded conversation. He was not trying to interview him. He had already had an interview with the Prime Minister of Sudan previously back in New York, as is noticed in the record. And so this while BBC is seemingly unnerved by the fact that they didn't have this opportunity to have this interview, an actual interview, sit down with the Prime Minister of Sudan, that does not change the characterization of what in fact it was and what the purpose of it was. Mr. Ahmed is an activist in Sudan. As I mentioned earlier, this is a war-torn country. There is a lot of humanitarian strife. In fact, there are a lot of humanitarian violations and issues happening right now and have been for the last several years. And so as a result of that, and I believe my time has expired. As a result of that, we absolutely do believe the manner in which this investigation was handled is an exhibit of pretext. We believe the fact that Mr. Andari was untruthful as it relates to substantive issues about the fact that he was involved in giving verbal permission for Mr. Ahmed to participate in this conversation, and he did not mention that. That is a very significant distinction that a trier of fact, not the judge at the DC Superior Court, should have been making a determination about.
All right, thank you.
Thank you.
All right, we'd like to thank both counsel for your briefs and arguments, and the case will be taken under advisement. Our second case this morning is, where is our second case this morning? All right, VERNELL, MCCRIMMON et al.
Good morning, Your Honors. May it please the court, my name is John Blake. I am here from Neighborhood Legal Services Program representing Ernestine McCrimmon, the appellant in this case. Since there are multiple Ms. McCrimmons involved in this case, I'll refer to appellant as Ms. McCrimmon. If I intend a different Ms. McCrimmon, I'll use their full name. Ms. McCrimmon is asking the court to vacate the trial court's order granting the petition to show cause that was issued on June 12th of 23 and remand the case for consideration of appellant's title via adverse possession of 2211 Lawrence Street Northeast. Ms. McCrimmon is a 66-year-old African-American woman who—
I'm sorry.
Yes, Your
I think we're familiar and appreciate actually quite a bit your brief in this case, as we appreciate the brief of the appellee. I think the facts are really not in dispute. So I'd like to get to the question of our jurisdiction over this case.
Yes, sir.
What is the basis of our jurisdiction over this appeal. Why do we have jurisdiction to hear this appeal?
Yes, Your Honor. So,
And you can preface or your remarks, your legal argument with sort of, if you would inform us as to the current status of the probate matter, which is ongoing, perhaps?
that's correct, Your Honor.
Okay, so then, given that it's an ongoing it's ongoing, thus this is not here as a appeal from a final order, can you tell us what the jurisdiction is of this court to hear this appeal at this point?
Sure, Your Honor. This court has the authority to review interlocutory appeals where there's a disposition of property. And so the disposition of property at issue is the 2211 Lawrence Street Northeast, which was part of the estate, or well, allegedly a part of the estate. There was a show cause hearing and my client was dispossessed of
You're
that
using the
property.
word disposition. I guess, are you talking about the 11721 as the basis for the jurisdictional point you're making right now?
Yes, Your Honor.
And you use the word disposition, the word in the 11721 A2 big C is changing or affecting the possession of property. And
Yes, Your Honor.
and certainly the order that was being appealed from did change or affect the possession of property. So I think it seems pretty clear that at least originally there was jurisdiction over an interlocutory appeal.
Yes, Your
I guess
Honor.
what makes it harder is that the property is now been sold twice, and I think it's undisputed, though correct me if I'm wrong about thinking it's undisputed, that there's no relief that this court or the probate court are going to be able to award that will change possession of the property back to your client.
That's correct, Your Honor.
And so then the question becomes, if that predicate for interlocutory jurisdiction is now in a way lost, we can't fix, to the extent there was an order that affected the possession of property, we can't fix that now. That aspect of that order is moot. The question then becomes, do we have jurisdiction notwithstanding that the predicate for it is moot? That's, I guess, one of my questions. And why would we take interlocutory, if the rationale for interlocutory review is you want to be able to get to the Court of Appeals to get a quick remedy to address orders that change or affect the possession of property. If now the Court of Appeals can't help you with that kind of reason for expedited interlocutory review, then why should there be interlocutory review over whatever remains, which isn't about, is not going to affect the possession of property? That's my question, I guess.
I understand, Your Honor. So admittedly, in a probate matter, it's a little bit of a strange duck, because what we're arguing here is that the property should not have been property of the estate in the first instance. And so if that's true, then the probate court should not have then given the personal representative the authority to take any action on it because it was not property that was within the body of the estate. It's true that the property was sold twice, and at least the second sale was to a bona fide purchaser, and so statutorily there's no relief that can be granted as to putting our client back into that property. But the predicate question remains: was this property that was part of the estate, should it have been distributed, or should the probate court have made any determination as to
I
the
get
property?
that question remains, and I guess the issue is, and it remains, it's a little unclear to me the way in which you understand it to remain. It could remain as the basis for some independent lawsuit against somebody for some kind of relief, or it could be remain as a claim that would be asserted in the probate matter, not to try to claw back possession of the house, but instead to say that that affects somehow the disposition of the assets that are in the estate. Are you hypothesizing that that issue remains a possibly live legal issue that could result in relief for your client in both those two ways, or only one of those two ways, or some other way besides those two?
Yes, Your Honor. So the relief that would be granted, assuming that, that the case were to be remanded back, that there were to be a hearing on my client's claim for adverse possession, would be, money damages. In this instance, it would be the value of the property, at
And is
the
that
time
something
of
you think-
sale.
And is that something you think the matter would have to be transferred to civil for, or is that a relief that you think you could get inside the probate proceeding in probate court?
We think we could get it in the probate court, but not necessarily as part of the proceeding. It would be an acknowledgement that the property was not part of the estate and therefore should not be distributed in the way that the rest of the property would be. And so
What prevents you right now, or has prevented you, if it has, from raising those claims in the probate matter? Maybe you have. Do you know if your client in the probate matters and ongoing has said, okay, look, there's this interlocutory appeal, and maybe you're just waiting until the interlocutory appeal resolves the matter. But let's assume for a moment, let's put it this way. Is it right to infer that to the extent your client thinks that those are remedies that might be available, they haven't yet been pursued in probate court?
So we don't actually think that those remedies are available, and for two reasons. The first reason is that the claims period for the estate has passed. And so there wouldn't be an opportunity to put in a claim against the estate for the property at this point because that has passed. And that in fact, that period had in fact passed before the show cause hearing occurred.
Before the show cause hearing occurred?
Yes, yes, Your Honor. So the claims period for the estate is a closed period, and then the show cause hearing occurred after that date. And so there wouldn't be a vehicle for requesting that relief in the probate matter. But
I just make sure it will become apparent from my question that I don't know as much about probate law as I probably should, and probate procedures.
Admittedly, neither do I, Your Honor.
If this idea of adverse possession is viewed as a claim against the estate for purposes of the probate procedures, and if that time period in order to do that had already run before the status hearing, then is there a timing problem that relates to how it is asserted even as it arises now? And if not, why not?
Right. So the purpose of the show cause hearing was to determine whether or not Ms. McCrimmon had any ownership interest in the property, and if she didn't, then why property should be turned over to the estate. So the estate at the show cause hearing was asserting that it was a property in the estate, and Ms. McCrimmon was inartfully attempting to communicate that it was her property and that it wasn't property of the estate. So
You're saying it was a defense at that point to an assertion for possession, and you shouldn't construe it as a claim against the estate.
exactly.
But if she needed to make any claims she had against the estate, and if you shouldn't understand it as a claim against the estate, what actually happened then, and she was required to make claims against the estate at some earlier point, then how will it help us send the matter back if she missed the time in which to raise a claim against the estate?
Because the property, whether the property is part of the estate, is not really a claim against the estate.
Right.
It's a factual question.
Fair
about-
enough, but if that's right, then why can't she in probate now continue to make the point that it should never have been understood as a property of the estate? And therefore that affects the distribution of the assets of the estate. That at least would be available from a temporal point of view. Perhaps a claim against the estate might not, or
Well, I'm not sure what the mechanism would be, because the probate court has decided that it is property of the estate, that it was within the personal representative's authority to distribute it, and the personal representative now would then distribute the asset, or the value of the asset, through the intestacy laws of the district from that. So the decision that it was a part of the estate has already been made at that point,
But
and
because that decision's been made, the probate court would be prohibited from deciding that that was an improper distribution and requiring the return of any assets from the sale?
Well, we think that the proper vehicle for getting the probate court to undo the determination is this appeal.
Right.
Why?
But if we don't have jurisdiction, it
Yeah.
won't be the proper vehicle. And so I'm just trying to figure out, if we're not the proper vehicle, is there any other vehicle? And, you know, those are maybe distinct topics, but maybe they're related. Um, so you think, I mean, the trial court never decided and never consciously decided an adverse possession issue.
Correct.
And that's part of your complaint procedurally in character. So if you, let's say we were determined we lacked jurisdiction and your client went back thereafter to the probate court and said, either we were, you know, inartfully presenting an adverse possession claim that is relevant to the proper disposition of the assets of the estate. You didn't perceive it. We tried to bring that to the attention of the Court of Appeals. The Court of Appeals said it wasn't the right, you know, that was no longer an interlocutory avenue of review. So we want to, you know, now make the point that we did raise this point, and really you need to decide it on the merits. That's an argument that could be made in the probate court. The probate court might be persuaded that that's untimely because really there never was an effort to adequately present an adverse possession claim. Maybe it would rule in your favor, your client's favor, who knows? But in theory, that would be a claim that could be presented to the probate court, at least as against the distribution of the assets.
I can't necessarily say that I think that's a likely outcome. As I said, the probate court made a determination about the assets and has already instructed the personal representative what actions to take. So what has stopped the distribution of the value of the property was this very action. And I would remind the court that the part of the reason why the property was sold is because the client did, you know, request a injunction, which, you know, because she was unrepresented and, you know, not a particularly sophisticated actor within the context of the law, was, you know, unable to successfully communicate to the court that, you know, stop, we need to hold the sale. So, part of the reason why we're here is because, you know, of the very issues that were at issue at the trial court.
Can I ask you another jurisdictional question? I know.
Yes, sure.
Your opponent in the reply in her reply brief cites a probate rule 136, and suggests that it confers jurisdiction on this court. You also filed a 28K letter referring to Rule 130. I have that vice versa, but in your reply brief you cited it, and your opponent filed the 28K letter. Are you relying also on the probate rule as a source of our jurisdiction? And if so, could you explain which part of the probate rule and what your thinking is?
We're primarily relying on the fact that this is an interlocutory appeal. You know, that there hasn't been a final decision in this case, and that as a result of that, yeah, this deals with a distribution of property, and therefore this court would have jurisdiction on that basis.
You said there hasn't been you're relying on the fact that there has not been a final jurisdiction, resolution of this case in probate court, but you just said that there has been, because the property was determined to be a part of the estate, and now it's proceeding through the personal representative to distribute the assets. Doesn't that conflict with the notion that this is an interlocutory appeal and that gives us jurisdiction?
So the final determination, the case terminates after the distribution occurs and a series of other processes occur. And so again, probate is a little bit different than other court proceedings, but it's our understanding that the end is the point at which the personal representative's authority ends.
So if the personal representative distributes the assets from the sale of the property, Ms. Vermeil would be entitled to a portion of the assets along with her other sibling.
That's correct, as an heir.
And the problem with that, from your perspective, is that Ms. Vermeil thinks that she's entitled to all of the proceeds for the property.
As to the 2211 Lawrence Street Northeast, that's correct. So if it's not property of the estate, then that money should have come to, it shouldn't have been sold in the first place, but that money should come to her first.
And is there, does this court lack jurisdiction to review a decision by the trial judge if that defense is raised and rejected in the probate court?
I mean, I would argue that my client did raise it during the show cause
I
hearing.
understand that, but let's say that this is an ongoing matter now. She can actually raise it.
Sure.
She can articulate it through you or someone in a very clear manner.
Sure.
Would that prevent, is she now, unless we decide this case, prevented from then raising that on appeal?
We would certainly try it, Your Honor.
Is there any reason why we wouldn't be able to hear it? I'm trying to understand, again, jurisdictionally, whether we are precluding her from her only opportunity, or whether our finality rule, and as we discussed, whether in fact we have jurisdiction now since the property is gone and can't be recovered, and therefore this appeal no longer is about as we talked about, the change or a decision that changes or affects property that we can actually do something about, right? So it becomes a question of whether, in fact, we should exercise interlocutory jurisdiction to decide this case when no longer when that jurisdiction may not exist. But part of my decision or thinking about that would be, well, is this something that would be precluded from a subsequent appeal if, in fact, she took appeal from the final order of the probate court?
Yeah, I mean, I think that there, to the extent that there aren't additional proceedings that direct specific actions, I'm not sure that there would necessarily be a final decision. I mean, the way that the probate court proceeds, assuming that there's not additional actions, it just sort of ends, right? The
court in that matter would end the probate, right? It would,
Right.
But then we'd have, I don't know, and that's why I'm asking the question. Does that final ending, sort saying that the property's been distributed, is that an appealable order? Especially if you raised during that proceeding a complaint or a challenge to the distribution of the assets.
Yeah, I mean, I think part of our concern here is that once the assets are gone, they're gone. And so getting a decision, months or perhaps even years down the road might not resolve the actual issue which came from this, from this mistake in our
Although
view.
if you're concerned about that, I assume you could seek a stay of the actual distribution of the assets in the trial court. And if you had a likelihood of success on the merits, and you could show that the assets would likely be unretrievable if distributed, you might be able to get relief.
Sure.
So let me just ask, so two variants of a question. Assume that this court determined it lacked jurisdiction.
Sure.
And then there's a final distribution of the assets. Couldn't you take an appeal and say the distribution of assets was incorrect? There was an adequately presented adverse possession claim that the trial court failed to consider, and having failed to consider it, it didn't correctly determine whether or not the estate really was not the proper owner, and in fact, your client was the proper owner. Wouldn't that be a claim you could raise in an appeal from a final distribution order, even if nothing else happened?
Yes, Your Honor.
And second, assume that a second variant, imagine that this court determined it lacked jurisdiction and your client filed a motion to reconsider whatever order it was that determined that the estate was the owner of the property, and say, here's our motion to reconsider. There was an adequately raised adverse possession claim. You didn't adequately, trial judge, pick up on that, so you didn't really adjudicate it. You need to adjudicate it, and let's go adjudicate. And either the trial court would say, okay, I'm going to grant the motion to reconsider. We'll determine an adverse possession claim, and that would get sorted out inside of probate, or maybe over in civil. A little unsure about that. Or the trial court would say, I'm denying the motion to reconsider. There was never an adequate claim of adverse possession in front of me, or whatever other reasons the trial court might have for denying a motion to reconsider. And if the trial court, whatever the trial court's ruling on all of that was, all of that could be brought up to this court by way of an appeal from a final order distributing the assets of the estate. Is that true also?
That's also true, Your Honor.
Can, looking at this matter that is currently before the court, given what the claim was below the argument on appeal, why isn't this jurisdictional aside moot anyway? What authority do we have to give you the relief that you seem to be seeking now, which is similar to what Judge McLeese has suggested? You could perhaps create a record to appeal later, because here the only thing you asked for was don't sell the house. The only thing up here is before us in this interlocutory appeal is I'm entitled to the house, but the house is gone.
So I would change our characterization of our requested relief. What we're asking for is to vacate the probate judge's order and to remand for instructions to hold a hearing on the basis of her ownership interest, which is what should have happened in the first instance.
We'd have to agree with you, right? We'd have to agree that, yes, she had this own. What would be the basis of us determining that that matter with this record? I mean, you know, again, you're asking us to vacate an order that, but the order putting the property into the estate, right? Is that what you're asking us to vacate?
The order was based on a hearing to show cause why my client, Ms. McCrimmon, did not own the property or have some other interest that entitled her to remain in possession. And so what happened at the hearing was supposed to be a determination on those interests, and what we're alleging is that that didn't really occur.
Well, is the basis for that allegation that didn't occur that the trial court failed to discern that Ms. McCrimmon was making a claim of adverse possession?
Yes, sir.
Because it wasn't filed in writing and it was made at the day of the hearing.
Yes, sir.
So talk about that a little more. I mean, the argument in your brief is that the court should give special or different treatment to, in this instance, where Ms. McCrimmon was not represented when she was trying to assert that argument to the court. And because she was unrepresented, the court has a special duty to construe her arguments differently. Is that essentially your?
So that,
I mean, if a lawyer had stood up without filing a written claim articulating adverse possession, we wouldn't be here. Is that?
That's correct. And I think it's not just that Ms. McCrimmon was unrepresented in our brief. And if you look at the transcript, there are a number of circumstances that make clear that Ms. McCrimmon was confused. In fact, the court referred in its footnote to the fact that that Ms. McCrimmon was, quote, possibly confused, and that she was going to be referred to adult protective services. There was references to her.
The court took great pains. I mean, the record seems to indicate that the court sort of painstakingly went through records and papers that Ms. McCrimmon had with her in court. So it doesn't seem from the record here that this is a situation where the trial judge was very cavalier. I'm just not going to hear you. She really appears to have gone through the documents that Ms. McCrimmon presented, tried to tease out and clarify a little more what Ms. McCrimmon was trying to assert, but ultimately concluded, I don't have enough here for a quote unquote claim to determine that a claim is being filed. Is that an unfair characterization of what happened?
I certainly disagree with Your Honor's characterization of the record, and I'll just say on page 6, which is a very beginning of the transcript, one of the first things that the probate court judge states to my client after identifying where she lives is that she doesn't own the house. right? And she continues to assert, you don't own the house, you don't own the house. My client then continues to add facts that put forward, in our view, of prima facie claim for adverse possession. And at every time
Which
she
were
she
what?
adds
What
those
were those
facts,
facts again? That she was living there for 50 or more than 15 years?
that she had lived there from the time of her mother's death until the present, which was more than 15.
But doesn't it have to be adverse and notorious? And here there seems to be a sense that her sisters and brothers knew she was there, didn't really seem to have a problem with her being there, which would seem to undercut an adverse possession claim, wouldn't it?
So the adversity is as to the record owner, which in this case would have been the estate, right? When VERNELL McCrimmon died, the property would have passed to the estate. And at that point, there was no one to give Ms. McCrimmon permission to reside in the property. The estate itself didn't have any personal representative. There was no other person with interest to do that. And it would, I think, be a different question if we had,
But
all of.
was all this spun out to the trial judge? I mean, I just don't see that level of legal analysis or even factual clarity being asserted in the record before the trial court. For her
And
to
that's,
glean, yeah.
yeah, I want to go back, and that leads me back to Judge Buckner, the Chief Judge's question about sort of this due process argument you're making, and your argument that it would only, that for a pro se litigant, this would be consistent with due process, and I want to ask you your support for that, legal support, authority for that. But I don't understand why it would be any different than for a lawyer. Why would there be a different burden on the trial court if it's a pro se litigant who sparks out, I lived there for 50 years ever since my mother died and it's my house, and a lawyer who says the same thing? What would the test be? If you could articulate what that test is, that due process test that we would then be suggesting trial courts have an obligation to adhere to.
So if you look to the closest corollary to a situation like this, it would be something like an eviction or an ejectment action. And if you were to go over to courtroom building B any day of the week in a landlord-tenant case, you will find pro se litigants walking in front defending eviction cases and saying things like, why didn't you pay your rent? Well, I have housing conditions, right? They're not articulating the elements of a warranty of habitability under a particular Javins, right? They're saying, here are my circumstances, and the trial court then asks questions to inquire whether they've hit the elements, and then says, okay, that we're going to proceed in this way. Either you haven't done everything you need to do in order to put forth that claim, so I'm going to take a continuance and please file some sort of appropriate pleading, or addresses the reason why the claim is not sufficient and moves on with the proceeding. And so that is really what we're seeking here. Is you have an unrepresented litigant again that the court identified was confused, was concerned about. And while I understand and agree with your honor about having gone through the documents, the initial response was, this is not your home. And then there was a statement about, it doesn't just become your home because you live there. That's not the way the law works.
Which is true as far as it goes, if you're
Right.
being very technical, because there are additional requirements. I get your point that it might not be very helpful to a pro se litigant who is groping for an adverse possession claim, but that was not inaccurate as far as it goes.
But it was a mischaracterization of her assertions at that point. She had already articulated that she had paid property taxes, that she had spent tens of thousands of dollars on fixtures, that she's holding her, she didn't use the word hold myself out as the owner, but she put forward facts that demonstrated that indicia. She repeatedly said it was her home, and the response was, it doesn't just become your home because you live there.
But Mr. Blake, she also provided the court with a rationale, her justification for why she believed it was her home, that had absolutely nothing to do with adverse possession. She said her father had given her the home, had given her and so all of those things you said are absolutely correct. If her father had provided her, had made her the heir, and that taken it out of the estate and given her the right to ownership of that home. So, and the court then, listening to her, said, oh, okay, and then proceeded to have an extensive conversation about that with her. How does that square with the idea the court had already made a decision and thus deprived her of due process?
So it's important to note that one of the normal factual predicates of adverse possession is a misunderstanding of ownership, right? Where was the fence? Where was the surveying line? How did you, was there a wild deed? How did you, obtain the property? So, I agree that, her initial assertion was that based on these documents that were not affected and did not operate consistent with the district law, that she owned the property. But I think that's further proof that she was asserting her ownership interest and that
No, she was asserting that was her ownership. You're asking us to somehow instruct, and this goes back to my test, the trial court, when they're presented with this type of evidence and this claim, that they have an obligation to not provide technical, you need to go file this someplace else because I now understand your claim, but to intuit what the claim could be, a substantive claim, provide her or a litigant with that defense, not like housing violations. What are your housing violations? Okay, tell me a little bit about those. When did they occur? And saying that if you want to claim housing violations, do this. This is actually not articulated in such a way unless that would give, and I know you're arguing to the contrary, but after that somehow by saying I lived there 50 years and made repairs to the property, if it's consistent with I own the property because my father left it to me, it certainly would be difficult to suggest there's a test that the trial court could undertake to then figure out whether if that's not effective, then give me three other, keep telling me and maybe I'll find something that's an effective defense, which it seems to be what you're arguing.
So virtually, yes, but I do take a different position than Your Honor about whether or not it's reasonable for a probate court in a show cause hearing to understand what the possible property interests are and to suss out based on those facts whether or not that's present. I think that's in fact the purpose of the show cause hearing is this property of the estate.
At one point you said that you thought that your client's statements at the show cause hearing established a prima facie case of adverse possession. And then you got some questions about that, I think, that were focused on whether the kind of adversity, maybe exclusivity, but adversity had been made out. Do you stand by the idea that you think if you take all the technical elements of adverse possession, the statements of your clients actually made out a prima facie case, or is that not the case, and that she got part of the way to enough of a way to a prima facie case to trigger, in your view, obligations on the trial court?
I think that she did put out a prima facie case on the facts. I think had she been given an opportunity to fully articulate that or technical instructions about
the facts
putting
on
forth a
adversity?
claim, it might have been stronger.
Yeah, and what were the facts that you think made out a prima facie case on
Right.
adversity?
So she articulated that she was in actual possession of the property, right? She'd lived there in the property from the time that her mother had passed until the time of the hearing, which at that point was beyond the 15-year statutory period. She asserted that she had paid property taxes and that she had paid for fixtures and repairs. So she had done what you would expect an owner to do in an open and
or someone who's living in a house with consent of her or his siblings.
I would disagree with that, Your Honor. There's no indication, and obviously it's not on this record, but I can tell you that
I understand. I'm just saying that if there's no evidence either way on that. There's no express evidence that her siblings did not give her consent to live there. That the other heirs, intestate heirs, did not give her consent.
Well, and that's where a hearing would have
No, I
clarified
understand that,
that.
but I get that. It would a hearing certainly could have fleshed all that out if the claim has adequately been brought to the trial court's attention. But if the issue is there was a prima facie case made of adverse possession, saying I live there without saying who the title owner is and I don't have consent from the title owner seems to me to be missing some pieces about adversity that you would think of as part of a prima facie case. I mean, you wouldn't think if someone filed a complaint, a lawyer filed a complaint for adverse possession and said, my client has lived in this place for 15 years and has paid taxes on it and made repairs. Therefore, you know, that I have established adverse possession. You'd say, no, you are missing some things. You need to make clear, you need to have facts and allegations that would indicate that it is adverse. You don't have consent from the owner, it's open and notorious and the like. And those would be missing from a complaint like that. And they seemed like they were missing here. So I have a hard time thinking that there was a prima facie case made out by your client's statements, which not to fault your client. I mean, your client is a layperson. She's not in a position to make you know, that lay out the elements of, you know, except kind of by good fortune, would she be in a position to make out the elements of an adverse possession claim? But
I think I disagree with Your Honor in that the probate court acknowledged that the property transferred from VERNELL McCrimmon to that of VERNELL McCrimmon's estate. And the court then said, you don't have any right here, right? And so I think that demonstrates at least the court's thinking that there would be, you know, permission would have, you know, passed along with that of VERNELL McCrimmon. So, you know, in a complaint
implicit in that, I mean, an adverse possession claim in this setting seems to have a lot of complexities to it.
certainly.
And I think it would have been pretty hard. It's hard to fault the trial court for not leaping, although, you know, the trial court may know a lot more, probably for sure knows a lot more than I do in lots of ways, but
Sure.
it seems to me that like how adverse possession works when it's against your siblings is its own doctrine. We don't have much law on that, but some jurisdictions do that would suggest that in that setting, your client probably didn't make out a prima facie case because you need more adversity than normal because there's a presumption of consent. How it works with respect to matters that are in probate, like whether you can adversely possess against an estate if you're an heir, you adversely possess against the personal representative of the estate or the estate somehow. That also seems to have additional complexities that aren't just your run-of-the-mill adverse possession case.
And
I'm sorry, that was a bit of my own detour for which I apologize. But a component of that went that route is because I started wondering about something that it seemed you were saying, which is if I have consent to live in a house that's owned by someone who becomes a decedent, and so that house then becomes a property of an estate. And I go and the estate is not put into probate, so there's no personal representative, so I can't go talk to a human who represents the estate. But I go to all of the other heirs and I say, you know, let's say it's an estate, it's intestate succession. So I find out everybody else who is a possible interest in this property. And I say, is it okay with you if I live in this residence? And I then do. You're not implying that I could adversely possess after 15 years because the people who gave me consent aren't the title owners and the estate would have to have been represented by a human who could have given consent and didn't? Or are you suggesting that that would be a way of getting adverse possession?
No, Your Honor, but I don't think we have facts here to indicate that all of the heirs provided permission.
We certainly don't. My only point was that if your claim is that your client made out a prima facie case of adverse possession, the question I'm asking is, would part of an adverse possession prima facie case be some indication of facts by your client that there was hostility and adversity? And if there wasn't anything either way, that might undermine your assertion that your client made out a prima facie case at the show cause hearing for adverse possession.
I don't think so, Your Honor, because adversity is assumed, assuming that you have open and notorious possession for the statutory
At least in
period.
some jurisdictions, that's not assumed when the other possible, the title owners are family members.
And certainly we don't have a lot of case law in the district that identifies what happens with heirs, but we do have case law on, you know, the presumption of adverse possession in the event that you have an open and notorious possession. And so, while I think that there would need to be, further development of the district's case law to identify what happens in air circumstances, we simply don't have that case law here.
And we only get to that, of course, if we find there's a due process violation. And I keep coming back to this because I'm trying to figure out what is your authority for the claim that in this particular case, under these circumstances, what the trial judge did violated her due process? What is, what case, for example, is there any case, or is this a novel argument that, and is it based on our instructions to trial judges through our, code that they should offer independent or technical assistance to pro se litigants in order for their case to be heard?
So what we're arguing here in the due process argument, Your Honor, is that, understanding that due process is a flexible, facts-based analysis, looking at the record here, and again, understanding that we're characterizing the record slightly differently, we believe that both because of what we believe to be the mischaracterization by the probate judge, but then also the way that the record reads very clearly, communicating at the very initial instance that this property isn't yours, you don't own it, the concern about our client's confusion, even the analysis in the decision about our client's credibility. There's a reference again to her carrying green shopping bags, sort of bringing up the cognitive linguistic frame of the bag lady. There's a reference that she was given an opportunity to find documents in these bags. If you listen to the hearing, you'll find that was a very short period of time while my client is bawling, and she it just didn't have the opportunity to really present that information. There's then a reference.
You keep saying opportunity to present that. She was unable to present it, or she didn't have the opportunity to present it, because see, due process does go to really opportunity to be heard, right? And for the trial court to take it. But is there something in the record where the trial court showed such impatience with her that we can claim, we can assume, or we can at least an argument can be made that the trial court really denied her an opportunity to present her argument to the court?
What I was saying before about the bags was, if you look at the representation that my client made about having paid thousands of dollars, there's a reference to that in the order, and then a statement that the personal representative made a representation that she had documentation. There was no inquiry into her showing that documentation and an instant belief that because she said it, it was true, right? And so if why was it true for the personal representative who presented no record, right, in this hearing, which was not a formalized evidentiary hearing, but in my client's instance, there's an indication in the decision that she can't be believed because she's got, bags and she's upset. And so I don't think that there's a particular point in the record where we can say this particular action was, the tipping point. But I think that if you look at the record in its entirety, of course, I don't know whether your honors have had the benefit of hearing the recording, but I think that would be instructive as well.
And can I just ask one last question? Because
Yes,
again, I'm trying to figure out, because yes, and it really goes to the issue of the test. I mean, it goes to, if we were to agree with you, we would have to fashion some kind of due process test for the courts, right? Can you tell me what it would say that is owed to this pro se litigant that wouldn't be owed to an attorney who made the exact same arguments here?
Right. So in McLeod, there was a series of articulations of when technical assistance might be due to pro se litigants.
Right.
And there was the reference for specifically technical procedural. There was the reference related to folks that are incarcerated because of their lack of choice. And then there was a reference to remedial statutes. And
Right.
so we would posit that in this circumstance, you have a dispossession of property. And if it were occurring at any other part of the court, as I said, if it were a eviction or an action ejectment, there would be more process involved, an evidentiary process involved in determining the interest before that action occurred. And again, typically trial court judges are very active in that, especially with pro se litigants who are unrepresented and are facing the possibility of losing their property. So
So you would ask for a fourth category,
yes, Your Honor.
dispossession of property.
Yes, sir, Your Honor. And we would add that, obviously in an instance where the court has identified that it's concerned about the ability of the litigant to participate, that just factually should raise some concern about their ability to participate and what experience of due process they're receiving.
All right, Mr. Blake, we've taken you well over your time, but we'll give you 2 minutes for rebuttal when you come back.
Thank you, Your Honor.
And we'll hear from Mr. Lannon.
Good morning, Your Honors, and may it please the court. My name is Robert Lannon, and I represent the appellee, the estate of VERNELL MCCRIMMON, through its personal representative, Linda McCrimmon, whose presence in the court I'd like to acknowledge. There are 2 Ms. McCrimmons in this case, as the court is aware, so I hope you don't mind if I refer to the appellant as Ernestine and my client as the estate.
How about if you just refer to her as Ernestine McCrimmon, just for formality?
For formality, I'm happy to do that, Your Honor. And the conversation that the court has just had with Mr. Blake is familiar to me because it's one I've been having with myself for the last 2 weeks to prepare for this hearing. But it loses sight of the fact that none of these issues, these very complex jurisdictional and procedural issues, need to be reached by this court to resolve this case, because in the existing record makes acquisition of title by adverse possession impossible. In fact, counsel says at the end of his reply brief, as a quote, "The issues raised in this appeal are purely legal and do not depend on any further development of the facts," unquote. With respect to the adverse possession issue, that's absolutely true, because there are 3 elements missing. Now, let's remember this, we're talking about a period here of 15 years. Counsel would maintain that 15-year period began at the death of their mother, and that it ended 15 years later, but that 67 extra days were taken before my client filed its show cause petition. So they were 67 days late. That's their theory. We disagree. We don't think that clock started really until that petition was filed because of consent, because there was no hostility. That's one of the required elements. And counsel said that adversity is not presumed. He just said that a couple of minutes ago. If the court holds that, it's going to have to reverse itself. Sears versus Catholic Archdiocese, this court, 2010. The court held that courts presume that one who occupies the land of another does so with the latter's consent. And if a party wants to establish that that's not true, it has the burden by clear and convincing evidence. Well, mom died, and when she died, there were 2 of her kids living in the house. It's not hard to imagine a scenario in which the rest of the family says, that's fine until we need the house. And the record is devoid of any indication that before my client filed that show cause petition, any of them ever said, hey, you got to stop living in mom's house. We got to sell the place. That just didn't happen. And then I mentioned the other thing that precludes the clock from starting when they said it does is the brother. The brother, Gary, I forgot his last name. I hope you don't mind if I just call him Gary, but he's referenced.
What is his last name?
Bonner.
Bonner. So how about we call him Mr. Bonner?
Mr. Bonner, excuse me, Your Honor. Mr. Bonner lived in the house. It doesn't say exactly how long he lived in the house, but as far as Ernestine McCrimmon was concerned, he still lived there. she says he's still there. Now he's in rehab now, but when he comes back, we're going to build a wheelchair ramp for him, and he still gets his mail here. That's his home too.
But why does that have anything to do with the ownership? It may be, in fact, that he's living there.
Yeah.
But the ownership that she's holding out isn't they own it. She's saying she owns it. And so what difference does it make if he's in there, if he's not claiming any ownership interest? If he gave her his ownership interest, if he, you know, and so she was continuing to, again, presumption aside, continuing to own it individually, or at least hold herself out as the only owner. And we have no record that suggests he didn't give the rights. I think part of the argument I hear from you is there is no evidence to support the claim, but of course she was not given the opportunity to present the claim because the court didn't understand that to be the claim that she was making, of one of adverse possession. The question is, on appeal, if the record is just insufficient, right? The record before us is insufficient. How can we determine that on this, well, let me ask it this way. On this record, how can we determine that she does not have a viable adverse possession claim when we have nothing one way or the other that has been decided by the trial court?
Well, I'll respond, Your Honor, in two parts to your question. I would have to reread the transcript, but I don't know that she ever says, I own the house. She says, that's my home several times. And she did allege an inter vivos transfer. So at some point she did assert that she owned it. He said, she did say that's his home too. That's his home too. You would have to jump to a conclusion that he's a guest. If we strike out the inter vivos, which the court did, it considered it. It read those documents. If we get rid of that, then you're left with, that's my home. That's my home. That's his home too. And he probably lived there longer than 67 days. We don't know for sure from the record, but probably. And counsel says in the brief too, in the reply brief specifically, that it's Ernestine McCrimmon's position that her adverse possession of the property extinguished Mr. Bonner's interest. Well, if that's the case, if he had an interest that could be extinguished by her adverse possession, then he had to have some title too. And if he did, and if he lived there for any longer than 67 days, then it must have told the statutory period for as long as he lived there.
Well, that raises another question that I had for you on the tolling of the statutory period. What is your position as to when the statutory period was tolled in this case?
It was told when the petition, the show cause petition was filed, because until then, there really was no adversity. There was no hostility. The true owner in this case, I understand.
Well, no, I'm a little confused by that answer.
Yeah.
I understand your prior point that the clock never started running until then.
Correct.
But assuming that the clock had started running earlier,
Mhm.
what event in this case do you think would have been sufficient to toll any clock that might have hypothetically started?
The probate petition, Your Honor.
So
the probate
before the
petition.
show cause petition, it was the probate petition.
Yes, the
itself.
probate petition. And
why
there-
and why the probate, that seems to me murky as a matter of our law. There is the language that your opponent relies on from Tippett, if I'm remembering the name correctly, that suggests that you need to file an action demanding possession. And
Yes.
the probate petition did not, at least when I looked at it quickly, demand possession.
It did not-
The show cause petition does, but the probate petition itself didn't even really explicitly claim ownership. It implicitly, I think, asserts that the estate is the owner.
It did, respectfully, Your Honor, it did explicitly by listing the house as property of the estate and by,
Right, that's, yeah, I mean, yeah, I guess you could debate whether how explicit or implicit that is. It's very implicit, maybe even explicit about ownership. What about possession?
well, it explicitly listed it as property of the estate, the probate petition. And if you look at the statute under DC Code Section 2702, a personal representative of the estate shall have the right, has a right to and shall take possession and control of the decedent's estate. And the probate petition listed the house as an asset of the estate. It identified Ernestine McCrimmon as an interested party. Indeed, she's an appellant, or I'm sorry, an appellee in this case and a party to this case.
So am I correctly getting, your idea is that it asserted a status that other provisions of law would make clear entitled the person claiming that status to possession?
Exactly, Your Honor.
So that-
And if there's, excuse me.
I think I got that. Can I ask you to back up a little bit? Because if I understood the beginning of your argument, you said we don't really need to get into the complicated questions, including questions of jurisdiction, because there's an easy merits answer.
Mhm.
And at least ordinarily, we're required to have a sequencing of our thinking, and we're not really supposed to decide merits issues unless we have jurisdiction.
I
And
understand.
so I'm not quite sure that I'm with you on the idea that we can jump over jurisdiction and dive right into an easy solution on the merits if there were one.
You make a good point, Your Honor. As for the court's jurisdiction, you noticed my 28K notification that I filed a couple of days ago. While I was preparing for this hearing, I bumped into this probate rule that basically said that was a final decision. Now, I found an interesting case, and I don't.
Can I ask you which subsection? I mean, it was that rule was also cited kind of in passing in your opponent's.
It is,
library,
it is.
but
I'm gonna have to, I think it's 126.
It's B something, and I'm.
Yeah, it's rule 126, and it says something like a ruling with respect to the disposition of property is a final rule.
Well, the pertinent possible subjects, I mean, I don't think your opponent cited a subsection either, other than B, but I mean like B. 4 is determining title to assets.
I think that's right. I
3
think-
is determining heirs or legatees. 5 is determining that property should be sold, but that is not an order that anybody is seeking a review of. So I wasn't entirely sure which subsection.
I think it's 4, Judge. I think it's number 4, and if they had filed their appeal as a final appeal of a final order, and counsel just said, no, this is an interlocutory appeal, we're primarily one, I think they would have stronger legs to stand on, but I would still have a counter argument. There is a case from this court, and I don't have the citation, but it says that the court's jurisdiction is statutory. And if there is a court rule that contradicts the statute with respect to the jurisdiction of this court, the statute trumps. So
Yeah,
it
that's
would be
a set of
incumbent
questions.
upon
Let me
this
just make sure I
court.
understand what you were trying to achieve with your 28K letter. Are you saying that you concede that, leaving aside the legal validity of this rule as it might confer jurisdiction beyond a statute, that the rule B4 would make the order that is currently on dispute here final for purposes of our jurisdiction?
Your Honor, respectfully, I won't make that concession. I filed that because I had not put it in my brief, and I believed it would be very instructive. And in an abundance of caution, I wanted to make sure the court was aware of it. It was before I reread the reply brief and realized that they had already cited it in passing. But I felt that I was ethically obligated.
I appreciate your filing it. I'm not at all critical of it. I just want to make sure I understand your position with respect to it. Do you think that let me put it this way. Do you think that the order currently at issue is an order determining title to assets?
Yes.
And do you think that the probate rule therefore describes that kind of an order as final for purposes of our appellate review?
Yes.
And therefore, if that appellate, do you concede therefore that if the appellate, I don't mean to say concede in a way that is adverse or anything.
Right.
But do you agree that if the probate rule is effective, which is again this question of whether it can confer authority beyond what the statute does, it would provide jurisdiction over the order at issue in this court as a final order in probate? That's
It
where
would if they had pled it that way, but they didn't plead it that way. They brought it here as an interlocutory appeal.
I see. So that your view is that this is an avenue of potential appellate jurisdiction that your opponent didn't invoke.
Not until their reply brief.
Okay, thank you. I just want to make sure I understood how you were fitting this piece into the
That's
puzzle.
yeah.
With respect to, and I don't know that you addressed this, but I'd like to hear your argument on why this is moot. Did you, if that is in fact the case, do you still believe that the that this case is moot, jurisdictional issues aside?
Well, it's a very good question, Your Honor. This is, the order on appeal was one in which my client sought equitable relief from the Superior Court, and that equitable relief was granted. That the equitable relief is moot. The house is sold. It's been sold twice, and you can't unscramble that egg. But what my opponent is seeking to do is to use the order granting equitable relief in our favor and an appeal of that order as an avenue to open legal relief in their favor. And that presents these fascinating issues of jurisdiction and procedure. I would, many of these points were made by my opponent in his argument. They have waived their rights to so much, and the court's indulgence. She did do one thing. She did file a motion to this court, asking this court to stay that order, and this court denied that motion. And she filed a motion to reconsider, and this court denied that motion. But there's more she could have done. She could have asked them to stay it, and she didn't. She could have filed a monetary claim, and she didn't. She waited till past her statute of limitations deadline, which I totally agree with my opponent's citation of that. What else could she? There are other procedural remedies she might have invoked. I mean, ultimately, Judge, if she had engaged Mr. Blake earlier, she would have done much better in this case. And maybe the tragedy of this case is that she didn't have counsel. Now, Mr. Blake is trying to get this court to invoke a new rule, where in addition to the incarcerated litigants, in addition to the statutes with remedial statutes, and in addition to matters of pleading and procedure, if it's dispossession of a property, that the person is entitled to tremendous assistance, enormous amount of assistance from the court. I'll just read, though, to be more precise in characterizing his position. This is his brief. Situations, quote, situations in which a pro se litigant is vulnerable, knows where the rights involved are vital, and where the consequences of their lack of knowledge have a high likelihood to foil their assertion of their rights. I think that that would be an exception that swallows the rule, that there is no special right for pro se litigants, because it would encompass nearly all pro se litigants in nearly all litigation in which they appear every day across the street in the Superior Court. And I understand we don't want to create a situation. With all respect, I don't think this court would have an interest in creating a perverse incentive where a litigant might do better without a lawyer than with. My guess is this court wants to encourage litigants to seek out talented attorneys like my opponents as early as possible. And while reserving all of my rights, I really believe that Ernestine McCrimmon would have done better in this case if she had done so, but she didn't. And because of that, she waived legal remedies that she wouldn't have gotten anyway because of my adverse possession arguments. She never would have established that on the record. But she waived them. And because she waived them, because she didn't call Mr. Blake until too late, there's no legal remedy this court can fashion.
So the mootness is where I started. You've sort of gone into the due process argument. And so I'm a bit confused. I'm really trying to focus on the mootness argument. Our case law, so would suggest, I think there are some cases that would suggest the remedy is impossible for us to give them, to give to the appellant, that therefore the case is moot and would be dismissed because we can't give them what they asked for below.
I agree. And not only is the equitable issue moot, I think the legal remedy that they're seeking to fashion here is also no longer available. It's moot. There are protections that were available to them, and Ms. McCrimmon, Ernestine McCrimmon, did invoke some of those protections. But because this court, did not stay the order, it's factually impossible now. And the statute of limitations had passed even before the show cause hearing for a monetary claim. So they want to fashion a cause of action. I'm not even sure what you would call it. Conversion on account of an erroneous court decision. They haven't even named what the cause of action is underlying their monetary claim, let alone presented it and adjudicated it to present something for this court to consider. And that speaks to my ripeness argument. And I think ripeness can be based on something other than an incomplete factual record.
So do you think that we discussed earlier with Mr. Blake that after the personal representative distributes the proceeds of the estate,
Mhm.
then it would be a final order that could be appealable to us again, perhaps. Is there any remedy at a later stage, or would we be back in the same position?
There might be a final order for this court to review. I don't know what that order would say or what cause of action it would be ruling on, because I don't know that such a cause of action even exists. It just hasn't been developed for this court to consider yet. And I believe all of the remedies available have been exhausted because of a statute of limitation and just the physical realities of this case. I see my time's expired, but if you have any other questions.
Thank you, Mr. Lanner.
Thank you, Your Honors.
All right, Mr. Blake, you have a couple minutes for rebuttal.
I went well over my time before, so I'll be brief. I just wanted to address this question of when the period of adverse possession would run. And I think, this idea that the adverse possession couldn't have started until the filing of the probate petition misunderstands the way that the adverse possession statute operates, which is also the statute of limitations on ejectment. And so the estate had the right to do whatever it was going to do with the property at the point at which the estate accrued the property interest, right? We know obviously that there was no personal representative, but at any time that there was a personal representative, there could have been actions taken. My colleague has talked about the possible actions that my client has taken, but in fact, there are a number of actions that the heirs could have taken in order to establish their property interests, such as filing a cause or an action to quiet title in the property. And they could do that even before there was a personal representative. In fact, there is a reference to that in a case, I believe it's in Ray Tyrell, that I cite in my brief. Where the family of heirs functionally attempts to circumvent the probate process by filing an action to quiet title in Superior Court, and this court found that they had the right to do that, right? That they had established an interest in the property and that they could do that as a quiet title action. Additionally, at the point at which Miss Linda McCrimmon became the personal representative, there was nothing stopping her from immediately filing an action to show cause why the property should not be turned over to the estate. She didn't do that until after the adverse the period of adverse possession of 15 years had run. And so, looking to the potential possibilities of actions here, one party with counsel engaged in a long litigation process. I pointing you to the record, I think my client was clear that she was unclear that this proceeding was happening. Obviously, there's factual allegations during the show cause hearing that there was notice, but there was never a determination about whether that notice occurred. My client asserted that there wasn't in fact notice. And so this idea that she slept on her rights until the last minute, I think is not is certainly a series of facts that are in contention. I see that I'm over time, so I'm happy to answer any questions.
I'm sorry to keep you one more question. I'm trying to understand, looking around, first of all, we don't have a lot of case law. Maryland does have some case law on this. In our cases, we've never foreclosed the possibility that hostility, for example, that would be antithetical to any claim of adverse possession, could be shown by the filing of, we've suggested that, showing that there is, what's the right word? In terms of the running or the tolling of the statute of limitations, at the point when there is a effort made in court by seeking to establish ownership of the property or put it in the estate. I'm trying to figure out why that would not be sufficient to toll the running of the adverse possession time frame.
I don't characterize the filing of the probate estate as being seeking possession of the property. What the filing of the probate estate does is attempt to identify at the point at which the petitioner is filing the potential property of the decedent and to seek the right to control that property. That's not the same thing as saying, you're in wrongful possession of this property and I'm seeking possession of this property. It's possible that the petition that the petition is wrong about what property interest the decedent has, and that's something that's determined over the course of the probate estate.
Could be, but it does signal that I believe I have an interest in this property, right? I guess the question I have, what concerns me is that most jurisdictions seem to not have a hard and fast, you have to file this document in order to establish your interest in ownership or your belief as to your ownership of property. It's much more flexible, and I haven't seen many cases where there is such a hard, the rule that you just articulated being dispositive. Is there any case law that you can cite to that is more definitive on the issue of when that notice is given to the individual in possession of the property that you believe it's yours, that you're hostile?
Yeah, unfortunately, no, Your Honor. There's a dearth of case law. I mean, I think our reliance is on Smith v. Tibbet and the arguably dicta, but I think it's clear, that there is a desire to move away from self-help towards, actions in courts. And I think a clear rule would be you file to determine, in many circumstances, what a property interest, whether there's a cloud on the title, who owns the property, like that is the mechanism that is used in every other circumstances. So why not here?
Thank you, Mr. Blake.
Thank you, Your
And
Honor.
Mr. Lannon, we appreciate your briefs and arguments today, and the matter will be taken under advisement and we stand adjourned at this time. Thank you.
Thank you, Your Honor.
All rise.